Qadiriyah and Mr. Muhammad Amar. Appearing together also the learned counsel for the defendant, Mr. Muhammad Amirul, Ms. Khairul Najwa, Ms. Nur Hafizah, Ms. Nurin Shakira, and Ms. Nur Shahira. It is an honor for me to appear before this honorable court. My lord, I will be submitting on the first issue for 5 minutes, while my learned co-counsel will be submitting on the next issue for another 5 minutes. Before I begin with my submission, do my lord appreciate briefly summary facts of the case?
Briefly.
Yes.
Just briefly.
Right. Much obliged. The plaintiff is in the business of providing television support equipment, and the defendant sought the plaintiff's expertise to reduce interruption in its satellite transmission during inclement weather, a phenomenon called rain fade, which was a defect inherent in the defendant's satellite dish. Towards the end, the plaintiff and the defendant entered into mutual non-disclosure agreement. Then the defendant had breached Clause 4 by disclosing confidential information for its own commercial gain. Then the plaintiff filed a suit for prohibitory injunction to restrain them from unlawfully relying or using part of the plaintiff's confidential information in their agreement and carry out any further disclosure of such information. May it please this honorable court, I will begin submitting the first issue regarding there is a bona fide serious issues to be tried in the plaintiff's claim. By referring the case of Genting Highlands Berhad and GM Aerosports in the Berhad, the High Court held that a bona fide serious issues determined in respect of the plaintiff's cause of action based on the totality of the facts presented before this court. And the court must satisfy that there is a prima facie valid cause of action and that the plaintiff's claim is not frivolous or vexatious. And we also refer to the case Solar Realities in the Berhad and United Overseas Bank in the Court of Appeal, where the court held that the word frivolous or vexatious generally refer to a groundless action with no prospect of success, often raised to embarrass or annoy the other party to the action. So in the case at hand, it is imperative to note that the plaintiff's cause of action relating to the act of defendant who breached agreement entered between them on 1st August of 2020. Defendant had breached such agreement by disclosing confidential information to the bidders who did not need to know pertaining the plaintiff's specifications and the recommendations made. Therefore, this is a serious issue that needs to be tried, since the right of the plaintiff against such confidential information had been disseminated to the third party without plaintiff's permission. It is also a serious issue when it is related to the breach of agreement made by defendant, causing the plaintiff's rights are affected. Additionally, the plaintiff's claim is not meant to embarrass or annoy the defendant, since the defendant had agreed at the first place. Defendant prohibited from disclosing confidential information disclosed by the plaintiff in the course of dealings between the parties pursuant to the Clause 4 of such agreement. Therefore, the claim is grounded because the plaintiff would suffer more in finding new investor, loss of reputation, causing them loss of customers, and loss of income in the long term due to the act of defendant who did not preserve the plaintiff's confidential information from the bidders. And the last part for the first issue, we also referred to the case of Seri Rosa Beach Resorts in Berhad and Asia Pacific Hotel Management in the case where the operator in seeking interim injunction need not prove a clear title. The operator is only to satisfy the court that there are tribal issues in connection with the right alleged and there is doubt as to the existence of such right. Therefore, in invoking the principle of existence serious issue in my plaintiff's claim that there is a doubt in the existence of the defendant's right in using confidential information in mutual non-disclosure agreement. At the first place, the defendant does not have a right to enjoy use in information in the course of dealing relating the plaintiff's satellite dish and exposed to the bidders by copying design of satellite dish. Therefore, we submit that the plaintiff has a reputable ownership upon the satellite dish and confidential information regarding satellite dish. Therefore, the plaintiff must prevent the usage of satellite dish confidential information by the defendant as it had been agreed under Clause 4. This shows that the plaintiff has a bona fide issue to be tried on to protect its own ownership.
Why is your praying for injunction?
Can my lord
I mean, in your notice of application,
yes,
why is the prayers for injunction? What do you want to injunct today?
we want to injunct the defendant from to restrain them from carrying out any further disclosure of confidential information.
Sorry? From disclosing confidential information.
Yes, yes,
But they have disclosed, right?
yes.
So don't you think that your application is now quite academic? It's still relevant, I mean, your application for injunction.
Because
Okay.
we will suffer more losses if the defendant still carry out any further disclosure of.
If you just suffer loss, should I grant the injunction? Can be compensated by damages, right? How are we going to reconcile on that issue?
But we also want to claim unmonetary damages.
Sorry?
We also want to claim unmonetary damages.
You are claiming monetary damages as well.
Yes.
So in that situation, should the court grant the injunction?
Yes.
But there is a legal principle that if it can be compensated by damages, injunction will not be granted. Why so serious the breach by the defendant to warrant the court to grant injunction?
Because Ganti want to protect its own ownership regarding the confidential information on the certificate.
Okay. Never mind. Proceed with your submission.
May I begin, my lord?